My spiel. Welcome to Fair Housing Friday. This is a series we started a couple years ago as part of Fair Housing Month in April. My name is Kalia Livingston, and I am the Fair Housing Project Education and Outreach Coordinator at the Champlain Valley Office of Economic Opportunity. Joining me today is Jess Hyman, our Associate Director for CVOEO's statewide housing advocacy programs, and our special guest, Big Hartman, who is the Executive Director of the Vermont Human Rights Commission. Big will discuss the mission of the agency and their role and responsibilities as the Executive Director of the Human Rights Commission, as well as their responsibilities as a litigator for fair housing cases. They will also walk us through the fair housing complaint process and the steps to reach a conciliation if it is found that illegal housing discrimination took place, and what those conciliations and settlements can look like. Thank you to the participants joining us today. Please keep your microphones muted as the interviews are taking place, and we will have time for questions during the last 15 minutes of the webinar. Please note that we are recording this webinar, and it will be available on our Fair Housing Month website, which is fairhousingmonthvt.org. We will do our best to make this dialogue accessible to all audience members, but feel free to ask for clarifying questions in the chat, where we will also be sharing additional resources as well. Before we hear from our guests, I would like to share some information about the Fair Housing Project. The Fair Housing Project is part of CVOEO's statewide housing advocacy programs. We offer fair housing trainings to all interested community members, including housing providers, service providers, municipal officials, anyone who is interested in learning more about their responsibilities and rights under fair housing laws, and additionally, people who are experiencing illegal housing discrimination. Before we hear from Big, I do want to give a special thank you to our sponsors and partners, one of which is the Vermont Human Rights Commission, for supporting our housing justice work. Let's pause for a second and take a moment to uplift our sponsors and partners. Here you can see all of the logos of the great organizations who are supporting our work and dedicated to housing equity and justice. We really appreciate all of their support each year, and want to highlight them whenever we can. All right. And getting to the good stuff, Big, can you introduce yourself and describe your role and general tasks and responsibilities as the Executive Director of the Vermont Human Rights Commission?
Sure. Hi, Kalia. Hi, everyone. Thanks so much for inviting me to join today. It's always a pleasure to do anything with CVOEO. Um, my name is Big Hartman. I use they, them pronouns. And yeah, it's a pleasure to be here. As the Human Rights Commission Executive Director and General Counsel, I am involved in overseeing all aspects of our work. So I oversee our intake process, our complaint investigations, our litigation, our policy work. We are involved in a number of committees and councils and work at the State House in trying to pass good civil rights and human rights, legislation each year. And I'm also involved in overseeing our outreach and community engagement, participating in events like this, leading our trainings. I do a bi-monthly fair housing training that's free. It's 3 hours long. It's a great opportunity for anyone who wants to know more about, folks' rights and responsibilities under our fair housing laws. I encourage you to sign up for that. It's offered typically on the first Monday of every other month from 9 to noon. I'm also available for any, special events or individualized trainings for any teams that want to get like a session live in person or anything like that.
Awesome. Thank you so much for describing a bit more about your role. What types of discrimination complaints are within your agency's jurisdiction to investigate?
Yeah, so we have three main buckets of jurisdiction. The one we're here to talk about today is fair housing. And so we'll get into a little bit more about what that means, I assume, as our conversation moves forward. We also enforce the Vermont Public Accommodations Act, which prohibits discrimination in any place of public accommodation. This is also where we have our Americans with Disabilities Act equivalent protections under state law. So that's going to apply to any folks who are using or accessing a place of public accommodation, which is extremely broad in Vermont. It includes any place that's open to the public or serves the public, any government entity or office, law enforcement activities, school-based activities. It's extremely broad. And so that's another big chunk of our work. And between fair housing and the public accommodations protections, that comprises of probably about 90% of our cases. But we also have a small area of jurisdiction involving employment law for any claims that folks in Vermont want to bring against involving employment discrimination against the state of Vermont as the employer. But all other employment discrimination complaints are going to the Attorney General's office, Civil Rights Unit.
Great, thank you. Do you ever see any complaints that intersect with any of those jurisdictions, maybe with employment and housing or public accommodations and employment or anything like that?
We do. We actually have created a new category in our internal system for cases that we believe implicate both fair housing and places of public accommodation. This includes things like potentially student housing, um, corrections, where you are actually housed in a correctional facility, but that is also a place of public accommodation. And then participants in the motel, hotel, shelter program, we think their housing situation is implicating both fair housing and a public accommodation, because motels and hotels are places of public accommodation, but when they're providing housing, both of those protections would apply.
Great, thank you for that. I've had some curiosity related to the rights of students and incarcerated people, so I appreciate you sharing both of those examples. Will you describe the fair housing complaint filing process?
Sure. I actually have a slide I'll share on that that I use commonly in public presentations just to give folks a visual of our complaint process. So hopefully you're able to see that.
Yep, we can see it.
Okay, great. And hopefully that's the only thing showing up on the screen, as I have all these little pop-ups appearing on my end. Okay, so on the left-hand side of the screen is where all complaints will begin, and that's in an intake process. Folks contact our office through a variety of ways to report discrimination. And primarily we see that happen through our website and through email. And also folks can pick up the phone and call us, and they can just stop by our office to try to initiate a complaint investigation process. Now, we have far more inquiries and requests for complaints than we're ever able to process here in our office. We only have 9 employees. 4 of them are the staff attorney investigators who are actually investigating the complaints that we accept for investigation. So through the intake process, our intake coordinator, John McKelvey, will gather information. We recently just launched a brand new online intake form. Anyone who's tried to fill out our online forms in the past might have been frustrated by a PDF system we were using that we have very happily done away with, and we replaced it with an online form. We also have a helpful video on our website about how to use that form in case anyone, is worried about going through that process. And you don't have to use the online form. You can just call us or you can send us an email. And we'll gather information through the intake process that helps us evaluate whether we have jurisdiction, whether your complaint is timely, and whether it meets our current criteria for acceptance. So we always are struggling, like many other civil rights agencies. We're struggling with resources. So we do have to make some tough decisions about intake. But for the folks whose cases we can accept for investigation, those cases are assigned a staff attorney investigator. And we're moving into that next phase on this chart, which is the investigation phase. During the investigation, our investigators are going to be gathering information from complainants, the people who have filed the complaint, the respondents, the people who the complaint is against. They're required to submit a point-by-point response to the allegations in the complaint and produce documents that are relevant to it. And then the investigator will conduct recorded investigative interviews with anyone with relevant information. We might also request documents from any third parties that might have relevant information for us. And during the course of the investigation process, our investigator is also trying to work with the parties to see if there's any possibility of resolving the complaint. And our investigators can be helpful because they are not representing either party in the case. So they can serve as a very helpful go-between for communications about what the parties would be willing to have happen to close out the complaint without a final determination. If we're not able to resolve the complaint, the investigators will write a pretty lengthy investigative report summarizing what information they gathered in the course of their investigation and doing a legal analysis about whether or not there's reasonable grounds to believe that discrimination occurred. That report is shared with our 5 HRC commissioners who meet once a month and hear those cases. The commissioners review the information from the parties about what, the parties are invited to respond in writing to the report and say whether they agree or disagree with anything in the report. And then commissioners invite the parties to come to an informal hearing process where they may ask some more clarifying questions or find out a little bit more about what disagreement or agreement there may be about what's in the report. At the end of the hearing, the commissioners will make a determination. Under the law, we're required to decide whether or not there's reasonable grounds to believe that discrimination occurred. If they find that there's no reasonable grounds to believe that discrimination occurred, that's basically the closure of our work on the case. And the matter is closed and remains confidential by law. However, if we find that there are reasonable grounds to believe that discrimination occurred, that determination is a matter of public record, and our work in the case continues. It creates a 6-month time period during which we're more actively involved in trying to see if we can help the parties with a settlement. And a lot of cases do settle at that point in time, now that folks have a picture of kind of what a judge or jury might do with the facts of the case. And if we aren't able to resolve it during that 6-month time period, then we have the option to file that case in court, where the Human Rights Commission is actually the plaintiff. And we have to prove our case to a jury, just like any other civil matter. And I just also want to mention that folks don't have to go through the HRC complaint process. Folks have the ability to file a lawsuit involving fair housing or public accommodations, or under state law for employment claims at any time, regardless of whether we are investigating or not, and regardless of whether we find reasonable grounds to believe that discrimination occurred or not. So I think that's the overview, but let me know if I left anything out and anyone has any more specific questions about our process.
Thank you for describing that process. Generally, about how long does it take to complete a case if it does go to that settlement stage prior to needing to litigate potentially?
So the average age of our case investigations hovers around a year. Cases that settle before an investigation is complete sometimes settle early on in the complaint process in the first few months. If a case, if we do find reasonable grounds to believe that discrimination occurred and we're still holding the case, we will generally see a settlement result in the first 6 to 9 months after the determination. And then litigation is a lengthy process, and it can take a few years before you actually get in front of a jury and have a case be heard all the way. Oh, I also want to mention, we also a few years ago created this guide for complainants and respondents that is also available on our website as well as in hard copy. And this has more explanation of some of the different stages of our complaint process, as we found we were getting a lot of common questions and we could answer them with a document for folks.
And if the complainant and respondent are able to kind of hash it out during that investigation piece and come to their own agreement, does your agency ever feel that there's still a need to continue the investigation, maybe to make sure that that respondent doesn't continue on doing discriminatory practices?
Great question. So if the parties work out a settlement in the course of our investigation process, that's great. We support that. We like to see that happen so that the complainant gets what they needed out of the situation. And we still, it doesn't forego our ability to initiate a complaint ourselves. The Human Rights Commission, we're using this tool more and more that's written in our statute that enables the Human Rights Commission ourselves to initiate a complaint. Sometimes this is useful when we're dealing with a large class of people that might be implicated by discriminatory conduct, or when there's not an individual who is feeling safe or able to initiate a complaint themselves. So it doesn't, a private settlement certainly does not take the respondent out of the gaze of our office, and we may still, depending on the facts, decide that an HRC initiated complaint is appropriate.
Got it. Thank you so much. And what does conciliation or settlements tend to look like after an investigation concludes that discrimination did occur?
Okay, great question. So settlements after a reasonable grounds determination are a matter of public record, first and foremost. That's required by statute. And that they usually will include two main components. One is what we call individual relief, something for the complainant that tries to make them whole for what they went through in being discriminated against. Sometimes that is monetary payment. Sometimes it is an apology. Sometimes it is a promise to do something for them, like if the whole case was about a reasonable accommodation request, maybe the part of the individual relief will be a promise to grant that reasonable accommodation moving forward. The second component of any settlement that we're involved with typically includes what we call public interest relief. So this is something that's going to make the Human Rights Commission feel like we aren't going to see this respondent in another complaint, tomorrow or anytime in the future. Public interest relief can be broad, and we like to try to be creative about what would send a message to the respondent that this is not worth their while to behave like this or to conduct themselves in a discriminatory manner. So usually it's going to include some component of training, that they promise to attend a training either offered by us or another entity about the issue in the case. Sometimes we're also seeing settlements that include a change in how they're going to do things moving forward. So there may need to be a written policy that didn't exist before about how they're going to process reasonable accommodation requests, for example, or a new applicant process if the case involved, an applicant for housing. And then sometimes we see benefit to requesting like a private donation for like a fair housing organization to ensure that they can continue to do their work. And then another form of public interest relief that we sometimes need to put in place is a monitoring agreement, an agreement that the entity is going to report to the Human Rights Commission on an ongoing basis going forward so that we can monitor whether they're improving their practices.
That's really helpful. I appreciate that all of those methods don't just put a Band-Aid on the issue and really help the respondent change their ways or their internal practices to actually address what could have caused the discrimination in the first place.
Yeah, we really see training as one of the basic needs across the state. A lot of housing providers, especially, end up with cases here because their staff have not been properly trained about fair housing requirements.
Mhm.
So it's an easy solution. And then we also want to see that you're going to make sure that new hires are also getting this training and try to institute some practices that will prevent any more discrimination.
Great. Thank you for the description of those methods that people can actually receive forms of justice. Can you describe how litigation begins if a respondent does not comply or agree to the terms of the settlement?
Yeah, so if we've got a signed agreement and it is being violated, even if it's an older agreement from several years back, if someone alerts us that they believe, for example, a housing provider is not complying with a previous signed settlement agreement, our senior litigator will take that issue up directly. He will contact the housing provider and put them on notice that we have heard that they are in violation and ask them to immediately remedy those violations. If we have any resistance to that, we will initiate an action in court directly to enjoin that person or assure that they come into compliance through the court process, which would ultimately result in a court order mandating compliance with that agreement. But if we aren't in the situation where we can't get to a settlement agreement, then HRC is going to initiate a lawsuit in most cases. Not always, but in most cases, we will file a lawsuit. We have to prove our case just like any other complainant, any other plaintiff. Like sometimes folks think that since we've got a reasonable grounds determination, that that's going to get some kind of deference when we go to court with that determination. But in fact, we have to, it's a de novo, it's a new review of the entire case. And so we will have to prove our allegations that we allege through the regular civil procedures. So, we'll go through discovery process, we'll do depositions and interrogatories, and then we will put on a trial if we aren't able to settle it at some point during that process. Usually, court cases have some kind of mandatory alternative dispute mediation process. And it has definitely been the case that when we couldn't get a settlement through our 6-month conciliation period, once we filed in court, often that will trigger someone to finally get an attorney when they maybe could have had one a long time ago and avoided some of these issues. Or insurance companies can get involved in that point, and then we can see a settlement result after the filing of a superior court complaint.
I have kind of a two-part follow-up question. First, what is the role or what could be the role of the complainant in this litigation process or preparation for it? And if the complainant decided to start their own lawsuit, is there any benefits from the commissioner saying that there were reasonable grounds for discrimination that took place for that person's individual lawsuit?
Yeah, so people can file their own lawsuits. They can be the plaintiffs against the same party that we're suing. Sometimes then we'll ask the court to join the cases, like for purposes of discovery, so that it's more efficiently done in that way. The the complainant, who becomes the plaintiff in the lawsuit, has the benefit of the information that we gathered through our investigation. They have access to our entire investigative file. They have the audio recordings of any interviews we conducted. They have copies of all the documents we gathered. That can be really, really helpful to get an attorney to represent you when there's all this groundwork already laid for why there's a basis to claim that discrimination occurred. And we do think folks would be more likely to be able to find an attorney to represent them with the benefit of our work already done on the case. And in a case where someone doesn't bring their own lawsuit, there's just a Human Rights Commission complaint, which is more common in housing cases in particular. In those cases, the complainant is considered what's called the aggrieved individual. They're the person who's been aggrieved. They're the person who still has a right to receive any compensatory damages for harm that they may have suffered. It can also be helpful for those folks to get an attorney that represents them individually as well, so they can get advice about what they should or shouldn't take in a settlement, for example, advice that our office that's initiating this lawsuit in the public interest can't really give them as much. And sometimes folks find a benefit, though, of having their own lawsuit because in addition to the discrimination they allege, there may be other civil law issues that they would want to raise. You know, we're only looking at discrimination in housing. So when there's other landlord-tenant disputes that might also have been, different kind of unlawful act by their landlord, for example, they would probably want to have a lawsuit that argued all of those claims in one case. And the Human Rights Commission isn't here to enforce lease violations or those kinds of things. We're really only allowed to address discrimination complaints.
Got it. So if the aggrieved person had some sort of issue where there was a breach of Vermont landlord tenant laws as well as for housing laws and the way that intersects, it could be beneficial for them to have their own attorney that could address more broadly or more specifically those Vermont landlord tenant illegal acts and how they coincide with the discrimination, but get more in the weeds of that conflict that they're facing.
Right. That's where it's really in the individual's benefit to have their own lawsuit initiated that can claim all those types of issues in addition to the fair housing violation.
Great. Thank you so much. What is the best way for a complainant to document their housing situation prior to filing a formal fair housing complaint? Is there any way that they could best prepare for if their case did end up being litigated?
Sure, absolutely. The, you know, the things that are most helpful for our investigation and even also for our intake process is if the person has maintained documents of what's occurred. If there's a lot of things that have happened over many months or years, compiling all of your text messages and emails, or, if you have any footage of anything that's occurred, maintaining those and making sure you don't lose that information is really helpful to your case. And sometimes also in those kind of situations where it's like a lot of things happened over time, we find a great benefit to a complainant who's able to creating a what we call like a chronology of events. Like on January 6th, we had this conversation. This is what I remember from it. To create that kind of chronology close in time to when it occurred can be really helpful, because sometimes by the time you're getting to an investigation or a lawsuit, we're talking a couple years later, and it's hard to remember all that stuff, back then. And especially if you're having a lot of communication verbally with the person that you're filing a complaint against, If you don't have the documentation, then keeping some kind of written record of what's occurred closer in time, or, as close in time as you start to create that chronology, is going to be much more helpful than trying to recreate events from your memory, 2 or 3 years down the line.
That makes a lot of sense. And when we support clients as well, I do, excuse me, recommend some form of chronological documentation. So it's really helpful that that could be something that is actually beneficial for them.
Yeah, and then sometimes folks are like, well, I have it all on my phone. I've got it here, so I'm good. You can lose your phone, and please make sure you have a backup of that information. We have had folks who, by the time it's time to produce their documents for the Human Rights Commission, they can't find them anymore because they got a new phone and they lost everything on their old phone or something like that. So always, always, always back that up. Yeah.
That's also a helpful note. Not everyone is the most tech savvy, but there are ways that I can make suggestions to help people keep up with their files, whether they're hard copies or uploading it to the cloud, whatever they need to do
Right.
where it's accessible. Can you describe some successes you've experienced with fair housing litigation?
So, I've been here with the commission for almost 5 years. And while we've had a number of lawsuits pending, we haven't gone to trial yet. The cases that have closed after litigation closed with favorable settlements for the individuals involved. And I do see that as a success. I think going through a court process is extremely stressful for an individual who's already been harmed and suffering from discrimination. And so whenever cases resolve, we are pleased with that. We've had some really great outcomes of folks who had long-term horrible discriminatory housing situations, and they have been able to achieve getting some financial compensation. I would say it usually in the range of between around $1,000 for a settlement of a fair housing case, up to as much as maybe 30 or more $1,000 in a settlement of a case that we were prepared to take to court. And also, there are folks that really feel they need the apology. They need, to be told that what they experienced was real and validated by the person who harmed them. And so we see that as a big victory. And generally getting to have closure in the matter can be really healing. And then, we are gearing up right now for a fair housing case that is scheduled to go to trial next month involving sexual harassment in housing. And again, we always prefer to see cases resolve without kind of having to re-traumatize that person through the litigation process. But there are certainly folks that are find victory and justice through jury trials. We just thankfully haven't had to go that far anytime recently.
Mhm. Well, I definitely agree with you that any sort of closure can feel like healing, and that can really differ case by case in what people are really looking for. And I hope that some of those monetary settlements can help fulfill some of the damage that was caused, but I'm sure nothing can fully heal someone from being discriminated against based on who they are. But I greatly appreciate your work and support for all of the aggrieved people. Are there any harsher consequences that a repeat offender of a respondent might receive if they continue to discriminate?
Yeah, that's a great question. So even through even in an initial violation case, even in an initial fair housing litigation involving a kind of a first-time offender, if we prevail, we would be entitled to not only get damages for the individual that was harmed. We would also be able to charge that individual for our attorney's fees in litigating that case. If we prevail, the defendant will have to pay us all of our costs and fees for the case. And we can request civil penalties be levied against that individual. So I would imagine that a court that has already found one person or one housing provider violated fair housing laws, if they're in front of that, if they're in front of the Superior Court again on another case, that would bolster the case for severe penalties against that entity.
Have you ever seen a housing provider be prohibited from continuing to be a landlord or work as a housing provider based on discrimination?
I have heard anecdotally that there was a case in which that happened. I actually think it happened in the context of a settlement that the Human Rights Commission obtained a promise from a housing provider who had a very bad track record that they would no longer be a housing provider. I'm not sure that I'm aware of any case in Vermont where that's happened from a judicial order, but
Mhm.
it's certainly something we could ask for as a form of injunctive relief. We
Mm.
can also ask for injunctive relief, like to change a certain practice that may have been discriminatory, so that moving forward they can't do that again.
Great, thank you.
Great
Um,
question.
are there any systemic barriers that hinder a complainant from getting adequate justice for how they were aggrieved?
Mm. Ooh, yeah. There really are. I think that the civil litigation system is rife with barriers for folks who are unrepresented, folks who don't have attorneys, folks who don't have resources, either financial or like I don't know, emotional to sustain through years long of an adversarial process.
Mhm.
I also think that, all aspects of the legal process entail a bit of ableism. There are barriers for folks that have disabilities in accessing our systems, being able to participate in depositions, answer written interrogatories, sit for long periods of time during meetings that are required or court processes. I think it presents a lot of barriers for folks. And then there's just the shortage of civil rights attorneys in Vermont that is a real serious barrier for folks in obtaining justice. There is no shortage of attorneys representing housing providers and property managers and landlords. There is only a handful of attorneys representing complainants and plaintiffs in these cases, and they are really outmatched in that way. And it's one of the reasons that the Human Rights Commission exists because, without, it's a no rights without remedies situation that what's the point of having fair housing rights if you don't have a way to remedy those violations? And our office is the only entity in Vermont that can investigate that claim and pursue justice if needed at no cost to the individual who was discriminated against.
Thank you for naming that point related to ableism because we do see that coming up with just the expectations of where someone is to file, how they're supposed to format a document, and all of that can definitely hinder someone from even wanting to pursue um, accountability from a person that has discriminated against them. If you could say anything, I guess, to an attorney to inspire them to represent tenants or do more of these discrimination cases, what would be the benefit to them?
I mean, I have been going around the state trying to beat that drum for a few years now. And I think that there are so many attorneys right now that are upset about what's happening to civil rights, especially at the national level, and want to know what they can do to feel like they're contributing to a more just world. A lot of us did go to law school because we wanted to be a part of fighting for justice. And I think that this is a really important role that attorneys can play, whether it's a foundation of their practice or whether it's on the side as their pro bono work. That there really is a great need for individuals, many of whom are, carrying the most marginalized identities in our communities, to be represented and get the benefit of good legal advice. And if you prevail in court, you can get your attorney's fees just like any other, workers' comp case or anything like that. So there can be, payment down the line, and there can also be settlement agreements that include attorney fee payments, so that, because it can be a lot to put out work for many months or years without seeing any payment for it. But there's a world of civil actions that lawyers are taking that risk with. And there is no reason not to take that risk with civil rights cases, especially when the Human Rights Commission has already done most of the work for you with an investigation.
Thank you. I appreciate everything that you've said so far and personally feel inspired as well by your words. So you're beating that drum loudly with a tune that speaks to me and hopefully to the folks who will watch this and who are participating.
Yeah, and if there are lawyers watching this or aspiring advocates who are watching this, one of our first efforts to really operationalize our dream of building the next generation of civil rights attorneys in Vermont is a continuing legal education program that we're hosting. It's virtual on June 10th. It will be with myself and our senior counsel who handles our litigation, Mitch Rotbert. It's 3 hours long. It's a primer on Vermont civil rights law to help make it more understandable for attorneys who are new to the field and want to get involved with representing folks.
Thank you for plugging that.
There's my plug.
And you mentioned earlier that what we're seeing at the federal level in related to our civil rights being chipped away, it can be a source of inspiration for attorneys to try to create more just communities. Has your work been impacted by changes to federal regulations that either add or decrease resources or services that your agency has been able to provide to Vermonters specifically?
Yeah, certainly. In the last year, we've seen decimation of staff that work, federal employees who help us and are partners with us in enforcing civil rights protections. So that it includes HUD, the Fair Housing and Equal Opportunity Division of the U.S. Department of HUD. It includes our partners at EEOC who do employment civil rights work. It includes also the the Department of Education, Office of Civil Rights, that, the interpretation of civil rights law that the current federal administration is trying to carry out really turns civil rights on its head. So there's been a reduction in staff, making their work less effective, and there's been a shift in their priorities of what they're wanting to enforce civil rights for. With our fair housing work with HUD, there has been a lot of difficulty getting paid for our last year of cases. We have a cooperating agreement with HUD where we do the investigations for HUD. For cases that implicate federal fair housing law, which is also incorporated in our state law. And, there is a lawsuit pending to try to obtain that payment, as well as challenging some of the new policy changes that HUD is trying to implement. We have been told both by EEOC and HUD that they will not accept for dual filing cases involving gender identity or sexual orientation discrimination. Those categories are expressly protected under state law and also have historically been protected as a form of sex-based discrimination under federal law. So we see that as a weakening and a pulling back of civil rights protections that is very concerning to us. But it certainly doesn't change that we are going to continue to do absolutely everything we can to hold the line here at the state level. We have asked for increased funding from the general fund from state dollars so that we don't have to worry as much about a lack of federal funds and don't have to have a reduction in our services during these times.
Thank you for sharing all those details. It's definitely frustrating, to say the least, that our civil rights are being eroded, and it's kind of, we're relying on the courts to make sure that we can continue to enforce these civil rights, and also the people who enforce the civil rights their civil rights are being eroded for the sake of trying to enforce civil rights. So it's just this spiraling mess, unfortunately. But
Yeah, but I do feel proud and assured that knowing that we are one of, maybe about 15 states whose attorney generals are actively challenging a lot of illegal federal action, including some changes that they're trying to make to civil rights enforcement. It's comfort to know that we're in a state that is willing to push back against that stuff.
I agree. And I'm grateful to be in Vermont and working alongside your agency, and all of the ways that we're able to collaborate have been really wonderful. Um,
Absolutely.
that was the last question that I have for you. So I want to turn it over to our online participants to see if folks have any questions. Please feel free to raise your hand and come off mute and ask Big your question. Right.
Whenever there's not questions, I always just tell myself that means that I've explained everything so well that there's no, no more questions to be had.
I do the same. Oh, it looks like one person came on video. Did you have a question for us?
No, I'm just saying hi. Thanks,
Hi.
Hi,
Lily.
Corinne.
Always nice to hear from you and see you.
You too.
Likewise.
And any thoughts or comments for Big? Doesn't have to be a question. All right. Well, I think you did do a great job. You answered all of my questions, and I'm regularly having questions for the work that the Human Rights Commission is doing. So thank you for um, playing into my curiosity and answering all of our questions. So I'll wrap things up a little early and give you all a couple minutes back. This webinar is coming to a close. Thank you, Big, for describing their work and how their agency enforces fair housing laws for Vermonters. I appreciate everyone for showing up and asking thoughtful questions and just thoughts. Please join next week's webinar on April 24th at 12 to 1 p.m. That webinar is titled Beyond the Sale, Ethical Real Estate and Power of Fair Housing. I'll be interviewing Jess Bridges, who is a longtime real estate professional. If you'd like to stay updated on all things fair housing related to CVOEO, please check out our website and follow our social media. If you missed any resources shared in the chat, they will be included in a follow-up email. And I will hand it back over to Big one time in case they have any more information that they want to share or events that they want to plug.
I think the events I would plug are listed on that one of those links that you've got there. I just really want to thank CVOEO, Kalia and Jess and everyone there. It's wonderful to have partners like you, and also give a shout out to Vermont Legal Aid. Deanna and all the work of the attorneys there who are doing their absolute best to help in protect our civil rights here in Vermont. So thanks everyone. We'll keep up the work no matter what.
Fair housing, no matter what, is
No
our
matter
theme this
what.
year. Thank you. That was a great way to end things. And thank you all once again for joining. And feel free to stay on if you miss anything in the chat and want to make sure that you have those links. Otherwise, you can log off, and I hope you have a great rest of your day and a great weekend.